Afternoon. I want to talk about one of my favorite topics, one of my absolutely favorite topics, and that is jury selection. Now, one of the reasons why we have jury selection on the program is because we're in Boston, Massachusetts, right? How many of you are Massachusetts practitioners? Raise your hands. I'm going to talk a lot about attorney voir dire. How long have y'all had attorney voir dire? 1 year! I know! That blows my mind. It blows my mind. It does. Jury selection, attorney-conducted jury selection, in my opinion, and I'm not the only one who would say this, is the most critical part of the trial. These are the people who are going to be deciding the guilt or innocence of your client. It blows my mind that all you got to do was submit questions to some person who's old wearing a black dress, who then gets to talk to the jury. So let's talk about this. Theme is from the heart, theory is from the head. That is a quote directly from one of my great friends in Memphis, a wonderful trial lawyer named Bill Massey. And Bill teaches at our Tennessee Criminal Defense College every year. It's a week-long trial training college that we give for newer lawyers. And your theme, as we all know, is what encompasses the theory of your case but engenders an emotional response, right? Your theory is your legal theory of the facts as applied to the law of your case. You start this in jury selection. By the end of jury selection, your jury knows the themes of your defense. Your jury knows your theory of the case. They know your heart and they know your head. This is a wonderful painting by Norman Rockwell that was on the cover of the Saturday Evening Post on February 14th, 1959. And it's a young woman seated in a jury room, surrounded by a bunch of white men. One of them is checked out over on the side there. And you know what's going on, don't you? Mansplaining. Probably mansplaining. Mansplaining that you need to vote to convict, right? You've got one holdout juror. And she's strong. And she's powerful. And you can tell. See, look, body language tells you everything. She's sitting ramrod straight in her chair. Her gaze is directly forward. She's not looking down. She's holding firm, right? She's holding firm. You want those jurors. You want those jurors who are going to be advocates for you and for your client back in the deliberations room, back in the jury room. And part of jury selection, critical part of jury selection, is the beginning process of giving those jurors, giving this juror in particular, the tools needed to be your client's advocate. How many of you have heard the phrase, we're going to pick a jury, or I'm going to pick a jury, right? As we all know, you don't pick a jury. You don't get to say, I think I want you and you and you and you and you on my jury. No. It's not jury selection, it's jury deselection, right? You're trying to get rid of the worst of the worst. Maybe you've got a panel and they're all bad, but you're trying to ascertain who's the baddest of the bad for me, right? That's what we're doing. And so our goals in jury selection, particularly attorney-conducted jury selection, number one, you want to identify those jurors that are hostile to the defense theory, right? And hostile to the defense theme. You know, that's for your for-cause challenges and your peremptory challenges. You know, in a child rape case or a sex offense case or, you know, a gun case or a drug case or a violence case, you know, for cause challenges, who are those people that just can't objectively sit on the case because of the nature of the case or the nature of the defendant, right? And then peremptory challenges, who are those that you can't put in the for cause category and get strong enough to get them there that you've got to burn a peremptory challenge on, right? And so that's one of the main things that you're doing. But it's not just that. You want to use the jury pool as your focus group for your theme and your theory. I can't tell you how many times I've gone into a jury trial, and by the time I'm done with jury selection, my phraseology has changed a little bit. My theme has changed ever so little bit. I've taken phrases from the individual jurors as they respond to questions, and I integrate those into my overall theme and theory of the case. I'll use them in opening statement. I'll use them in cross-examination. I'll use them in closing. And how many of you like to have said back to you what you've already said? Right? You sit there and you think, yeah, that's right. That's right. You're saying what I said. Right? That's powerful. And so you can also use those jurors during attorney-conducted voir dire to, like I said, as a focus group to test out certain parts of your theme and your theory and get feedback and talk to them, engage in a discussion about it. That is really powerful. It's really powerful. And in the course of, number one, identifying those jurors hostile, in the course of moving them toward a for-cause challenge, you have a real opportunity to educate the other members of the jury about your theme and theory in the way in which you question that juror. Now, beyond using the jury as a focus group, and this is tied in with that, you're beginning to advocate your case. You're planting seeds about particular parts of your case, particular aspects of your case. You're beginning to plant those seeds, all right? And we all know how to do that as trial lawyers, primacy and recency, okay? But you're beginning to do that in jury selection. And then finally, you're developing rapport and credibility with the jury. It's the only part of the trial, if you're able to do attorney-conducted voir dire, it's the only part of the trial where you get to engage in a conversation with your jurors. You get to ask them questions, and they get to talk back to you. And so one of the most critical things is, this is not just you talking at the jurors. Can you fairly apply the law? Raise your hand if you can fairly apply the law. Can all of you over here, you see my defendant sitting here, can all of you give him a fair jury trial? Raise your hands if you can do that. What are you learning with that? Nothing. Gosh, I've seen lawyers do that so many times, and it just makes me... You're wasting the ability to conduct attorney voir dire. You might as well be submitting questions to the judge and have the judge read them, right? So, part of this is developing rapport and credibility, learning information, but getting the jurors to like you. And everybody has to do that in their own way. You can't be somebody else. You got to be you. You have to be genuine. You have to engage in a conversation. All right. One of the reasons why attorney-led voir dire is so scary for lawyers is because you give up control. We're criminal defense lawyers. We like to ask questions that we already know the answer to, right? We like to conduct cross-examination. How many of you think direct examination is hard? It is hard. For a criminal defense lawyer who's used to just tearing into witnesses and doing cross-examination, like, yeah, this is fun. I'm beating you up. But it's a lot different to do direct examination, right? Because with cross-examination, you're really the witness. The witness is just a sounding board for whatever you want, what fact you're trying to get across. With direct examination, you're directing the witness and you don't have as much control, right? Jury selection is even less control than that because you're asking prospective jurors about things that you don't know the answer to. And so you've got to listen. You've got to listen. And this is really, really, really hard to do effectively by yourself. Those times that I've had to conduct a jury trial and do jury selection by myself, it's hard to keep up with everything. It's hard to ask the questions, think about the answers, and then loop. Take what one person has said over there and then go, oh, Mr. Jones, how do you feel about what Ms. Smith just said? Do you agree? It's hard to do that and hard to integrate that information in. And so you really need to have someone else there with you to do it effectively. Even if it doesn't have to be a lawyer. Okay, I've had law students who've been working with me. I've had college students, a staff member who's not a lawyer, a volunteer, and think, well, what do I know about jury selection? Well, guess what? The jurors don't know anything about it either. You're trying to have a conversation, and you need someone else who can watch them and gather information. Now, there's another aspect of control here, and that is who's in control of the room, the judge or the lawyer. And I'm going to give you 3 examples. The federal rule on jury selection is really all judge control. Judge has complete discretion. Judge can let lawyers do it, but doesn't have to let lawyers do it. In Tennessee, we're a jurisdiction where our rule is actually mandatory. A judge doesn't have discretion. He has to let us, or she has to let us, conduct attorney-led jury selection. Massachusetts, I was looking at your rule or your statute and kind of parsing through its provisions. It's really interesting. It's still what I call a judge-controlled jurisdiction, but with direction to the court on how to have the lawyers have some control, right? And so in a way, it's a little bit better than the federal rule, not quite as far as what some states like Tennessee have. So in looking at Massachusetts, I sort of call it a hybrid model. Let's delve into the details real quick. Federal Rule of Criminal Procedure 24A, Rule 24 is the federal rule on jury selection. It's really short, 24A. Trial jurors, examination. Remember what I said about control. In general, the court may examine prospective jurors or may permit the attorneys for the parties to do so. Really interesting. The court doesn't even have to examine them herself. Court examination. If the court, note it's still permissive, if the court examines the jurors, it must permit the attorneys for the parties to ask further questions that the court considers proper or submit further questions that the court may ask if it considers them proper. A lot of judge control, right? A lot of judge control. And so what I have found in my practice is that in those federal jurisdictions where I've tried cases where in state courts there is not much control for the lawyers, that the federal courts sort of mirror the same thing because that's sort of where the judge grew up as a lawyer, right? And those states where there is sort of wide open lawyer control of jury selection, the federal judges are more relaxed and they let the lawyers conduct attorney-led voir dire, just because that discretion is so broad. Now, let's compare that to Rule 24 in Tennessee. By the way, we're really easy. All we did in Tennessee is we just basically took the federal rules and then we've tweaked them a little bit, but the numbering's all the same, and so it makes it really easy to go back and forth between the rules. Tennessee Rule of Criminal Procedure 24. Look at this. Now look at the difference. Initial actions in jury selection by counsel. The court shall permit counsel to introduce themselves. And look at this. You get to make an opening statement before you ever make an opening statement. Shall permit counsel to introduce themselves and make brief, non-argumentative remarks that inform the potential jurors of the general nature of the case. And really the creativity comes in and, what are my non-argumentative remarks going to say, And then, subpart of the rule on questioning potential jurors. Questioning jurors by court and counsel. The court may ask potential jurors appropriate questions regarding their qualifications. And so it's permissive by the court, but what does it say? It shall permit the parties. You ain't got discretion. You got to let the lawyers ask questions, right? To ask questions for the purpose of discovering bases for challenge for cause and intelligently exercising peremptory challenges. That's really broad. Now, and then we have built into our rules specifically, if there are those topics or those things that are so sensitive that you don't need to talk about them openly in a group, on motion of a party or its own initiative, the court may direct that any portion of the questioning of a prospective juror be conducted outside the presence of the tentatively selected jurors and other prospective jurors. And in other words, get individual voir dire with that juror. And I've had courts do that multiple ways. I've had courts actually bring the juror up to the bench, and you sort of have a bench conference where you conduct voir dire with that individual juror. I've had courts actually have a separate room. We go back to chambers with the court reporter, we go back to a conference room, or they do it in the courtroom and they have the jurors in some other room. And you, in open court, you conduct individual voir dire with that particular juror, usually in child abuse cases, sex offense cases, things like that. Now, Massachusetts, your hybrid. Upon motion of either party, and this is what I call your for-cause rule, right? Those of you that are practicing in Massachusetts, right? You know this? This is your what I call for-cause, section 67A. Upon motion of either party, the court shall, or the parties or their attorneys may, under the direction of the court, basically ask all those questions that get at for-cause issues. You know, whether or not they can fairly apply the law, whether or not they can appropriately apply the burden of proof, do they have biases, prejudices, stuff like that. And so, if you raise the issue, the court has to do it, but the court can allow the attorneys to do it under the court's direction. And then it also has that same provision built in here, like I just went through with the Tennessee rule, where you can even have individual voir dire with a particular juror, okay, concerning, specifically with respect to such considerations, attitudes, exposure, opinions, or any other matters which may cause a decision to be made in whole or part upon issues extraneous to the issues in the case. Such examination may include a brief statement of the facts of the case, to the extent the facts are appropriate and relevant to the issue of such examination, and shall be conducted individually and outside the presence of other persons about to be called as jurors or already called. So you've got built into your rule that same individual voir dire provision that we have in Tennessee. That's why I call it a hybrid. You've got some good direction in Massachusetts that the court has to let you do certain things with your jury when you're conducting jury selection. But so much of it is permissive. And then when you get to Section 67D, the actual oral examination of jurors, you know, in addition to whatever jury voir dire, the jury venire is conducted by the court shall permit an oral examination of the prospective jurors at the discretion of the court. And so, in criminal cases involving multiple defendants, you know, that's when it gets into some of the other procedures. And so there are some things on the court that are mandatory. There are some things that are permissive. It's a hybrid jurisdiction. There's still a lot of judge control. How many of you that are in Massachusetts have tried a case recently where you've had to do attorney-conducted voir dire? How much leeway has the judge given you? Quite a bit? A lot? Just free leeway. That's powerful, isn't it? Scary though, right? Yeah, it was scary as heck, particularly when you're not used to it. All right, now let's get down into practical stuff. I wanted to go through the law with you, but now let's talk about implementation. In your materials, you have a ton of stuff that I gave you, right? I gave you a motion and memorandum for a jury questionnaire. I gave you examples of voir dire outlines. I gave you some transcripts just to kind of see how it looks in practice. And so let's talk about that stuff now for a second. Jury questionnaires. I love jury questionnaires, and they're not in lieu of attorney-conducted voir dire, but the way you get the court to give them, and I'm talking about more than just name, rank, and serial numbers questionnaires, but the way you try to get the court to give them is that this particular case has issues that we need to get specific information about from our jurors initially in order to make the attorney-conducted voir dire more effective. All right? So it's not in lieu of attorney-conducted voir dire, but these are sorts of issues that otherwise we're going to be wandering around about, and it's going to take jury selection longer. That's the way you sell it to a court, okay? Sensitive topics for individual voir dire. And then down here, I have abnormal psychology and scoring jurors. How many of you have a little system where you score your jurors, your prospective jurors? Right? I'll tell you my system. It's just 1 to 10, really easy. Okay? A 10 is a really good juror. A 1 is the worst of the worst. All right? And let me tell you, most of my jury panels end up being like 3s, 2s, and 1s. And so it's just, how do I get rid of the worst of the worst? And you have a different type of juror or kind of system initially that you're looking at. And in the questionnaires, some jurisdictions, you just get name, rank, and serial number with your questionnaires, right? You just get the initial panel information. If you try to get a written questionnaire to be distributed in advance, the ideal way to do it is they're called in, they're given the questionnaire, they fill the questionnaire out, then you have the questionnaires for a few days or a week or two to digest and analyze and score and work on. I've had cases before, though, where I get the judge's like, okay, I'll give you a questionnaire. He has the panel fill the questionnaire out, and then I get a whole bunch of questionnaires 15 minutes before I have to start jury selection, right? That's even harder, too, because then you've got to integrate a whole bunch of additional information into what you're doing. Yes, sir, you had your hand up. No? I thought you were raising your hand. So that... questionnaires can go back and forth. But what I mean by abnormal psychology in scoring jurors, there was a psychologist I used to work with in jury selection. His name was Dr. Bob Beber, who's now passed away. And Bob was wonderful. He was from Newark, New Jersey. And somehow he ended up in the hills of East Tennessee. I don't know how. But what he would do is he would sit sort of not at counsel table, kind of back there in the audience, and he would just watch the jurors. If you had jury questionnaires, whether it's just the court's questionnaire that they had filled out with name, rank, and serial number, or if I had a case where I'd gotten additional information, what they would do, or what he would do, is he would look at things other than just their profession and what they did, and spouse, not spouse, partner, not partner, kids, no kids, whatever. He would also look at their handwriting. All right? And he sort of had opinions about people, and a lot of them turned out to be correct based on their handwriting. Do they have big loopy handwriting? Is it real small and constrained? Is it slanted too far one way or too far the other way? Is it ramrod straight up? He would have all these sorts of impressions and thoughts about someone's personality and the way in which that they would filter information based on that initial impression. And so those sorts of things, if you have questionnaires, those sorts of things, the initial rank that you give your jurors at the beginning, that helps you. But then when you go into actually asking them questions, you're able to get additional information. Now, I always have an outline. I don't do it cold. Even though I can, like the rest of us, I can have an outline in my head because I've done it so many times, and I can kind of rattle through the different things I want to rattle through. This is every bit as important, if not more important, than your opening statement, than your cross-examinations, than your closing argument. And so to the extent that you would outline those and be very thoughtful about those, you outline your voir dire. And I've given you examples of some voir dire outlines that I use. Plan it out, but don't read it to them. How many of you have seen lawyers in jury selection, they're asking the jurors questions, the prospective jurors questions, and they're just reading questions, from their outline. If you agree with that, raise your hand. How many of you have seen that? Huh? Yeah. That's not telling you much. It's not very effective. It's also not engaging. You have to get the jurors talking. And here's a little technique that I like to use. I ask people, what's your favorite TV shows? Anybody like TV shows having to deal with the law or trials or cops, or CSI or Law and Order, Special Victims Unit, or, I start asking them stuff like that. And you start asking stuff like that, people are like, yeah, I like that, or I like this, or I used to like this old TV show, or I used to like that old TV show. And once you get them talking initially about something easy like that, number one, you're going to learn a lot of good information because you're learning what information they're intaking from popular media, right? I mean, it's surprising. You can learn a lot of information just on whether or not someone likes law TV shows a lot, or cop TV shows a lot, or trial TV shows a lot. Or if they like bass fishing television shows. I mean, you get them talking. And once they start getting in a conversation with each other, and a conversation with you, it breaks the ice. Because part of what you're wanting to do is you are creating an environment where you can then start talking about really tough stuff. You can get into racism, you can get into biases and prejudices, you can get into mental health issues, addiction issues, and whether or not what their personal experiences are with things like that. Now that's some powerful jury selection, but you just can't hit them cold with that. You got to get them talking. I like to use TV shows, movies, things like that. And then you're also planting seeds. Now, I have a transcript in your materials of kind of a planting seed situation. I once had a child rape case in Knoxville, and my client was a monk in a monastery in South Carolina, a little town called Moncks Corner, north of Charleston. Rock's looking at me, he's like, yeah, I know where that is. Little bitty town. All right, and they got this monastery. But that literally monks dressed up as monks. They walk around chanting and do all the stuff that monks do. And it was a repressed memory case. He, before he became a monk, supposedly had molested his stepdaughter, who was 6 at the time when he lived in Knoxville. And she had repressed the memory, and so by the time she was 16, she was remembering it, supposedly. And of course, by then, he had divorced, he had gone through this existential episode in life and become a monk and was living in a monastery. And the detective who in Moncks Corner had gone out and interviewed him at the monastery had gotten him to confess. So I had a confession from a monk in a monastery I was dealing with in that case. All right? And think about this: child sex, monk, Catholic Church. Ugh, I got all sorts of stuff in jury selection I got to deal with, repressed memories. But what I did in that case, I wanted to go interview the detective who had interviewed my client. And this is one of those interviews that was just a written report, not audio recorded, not video recorded. It's just the report of the detective. And so I called him up, and I said, his name was Gino Altieri, the detective's name. I said, Gino, I'm Steve Johnson. I'm from Knoxville, Tennessee. I'm going to come over and do a little investigation on this case, and do you mind if I talk with you while I'm over there? He's a small-town cop. He goes, well, no, that's fine. You can come over and talk to me. And then I said, I don't know where I've never been to Moncks Corner before. I'm driving over. It takes me about 6.5, 7 hours to get over there. I said, I'm getting ready to get on the road here in a little bit. I don't know where to stay. Where should I stay in Moncks Corner? Interesting question to ask a detective, right? And so he said, well, I don't know. I'll have to think about that. And I said, well, do you mind if I touch base with you when I get into town? He said, yeah. He gave me his cell phone number and said, meet me, at this little town square. He gave me some directions. So I drive over there, and when I get there, he's already at the town square in a giant Chevy Suburban with the sheriff's placard on the side. His wife's in the car with him. His wife works in the courthouse. They roll the window down. And I introduced myself, and he goes, my wife and I were talking. There's only one hotel in town, and it rents rooms by the hour. So we don't want to put you over there. I guess they looked at me and thought I was kind of innocent and didn't want to send me over there. And just come on home with us. So I spent the night at the detective's house. And that night, his son still lived with him, and his adult son that they took care of. And I got to know the detective pretty well and his family. Went out to dinner with him that evening. Of course, I talked about the case and kind of interviewed him about the circumstances of the confession. And, we joked about the nature of the case, a confession from a monk in a monastery, all this stuff. The next day, he drove me out to the monastery, I met with the head monk, the abbot. And then the detective left, he went on, and then I conducted my investigation there at the monastery. And so fast forward to trial. I knew that witness was going to testify at trial. He's the critical prosecution witness. He's the one that garnered the confession from my client. I knew that was going to be a big deal, and so I planted a seed in jury selection when I was asking about movies. And I was just waiting for the right juror to say this, but I had a juror, an older man. He goes, I don't know about any of these new TV shows. I like Perry Mason. I was waiting for that. I said, I like Perry Mason too. My dad used to watch Perry Mason. You know what I love about Perry Mason? And they're all like, no. And I'm standing by the prosecution's table. The prosecutor never wins. And they're all laughing. And then I said, the other thing I love about Perry Mason is that he not only was a good courtroom lawyer, but the way in which he solved his cases, he investigated them. And he went to the scene and he talked to the witnesses so he could find out what the truth was. Those of you that have seen Perry Mason, did you know that? Yeah. And, Mr. Jones, you said you liked Perry Mason. Is that the reason? One of the reasons why you liked it? Yeah, he was really good. He wanted to really find out what the facts were. Boom. What am I setting up later for when I cross-examine Detective Altieri?
Did you investigate?
My investigation, my credibility. I wanted to really find out what happened. I was someone who was credible, who was telling them the real story of the case. All right? And so when that cross started, first words out of my mouth, Detective Altieri, we've met before, haven't we? Yeah. And I went to your house to go investigate this case, right? Well, yeah. He says Southern hospitality, And so and the jury was laughing all through his cross. Even when I got to the really difficult parts of the facts of him talking about these awful things that he had done to his 6-year-old stepdaughter, then there were parts of that confession about I was not in my right mind at the time. I'm sorry. I feel horrible about this. My defense in that case was a mental health defense, diminished mental capacity. Jury acquitted, even with a confession. Okay? But it was because, and so much of the jury selection in that case is where that case was won, but that's one little component piece of jury selection in that case of planting a seed. Something that you know that's critical, that's coming later. Start planting those seeds with the jury because that resonates with them and that's going to connect them back to the case. And also, it helps give you credibility as the person who's going to be telling them the truth. They're going to be looking to you. When a witness testifies and then you get up to start doing cross, they're going, okay, now we're really going to find out what happened. Right? You're building that credibility. And then you're also, we all were laughing when I was telling that story, right? About Perry Mason. They do that too. And you're developing this environment where sensitive areas can be discussed and covered. Racial bias, mental health issues, gun violence, drug and alcohol abuse, addiction, sexual abuse, domestic abuse. I've had, in that same case involving the monk, I was having individual jurors answer questions, and they were freely doing so and talking about their mental health problems, people they knew who had mental health problems. I had one juror, prospective juror, she didn't end up on the jury, but she was talking about her own mental health problems because she suffered from bipolar, and bipolar was the main issue in that case. That's what my client suffered from, a type of bipolar where he floated from hypomania to mania, for those of you that have kind of studied bipolar a lot. And she was talking about that, and she said, mental health issues are a bitch. In those sorts of states, you just can't control yourself. Now, that's an example of my focus group, right? Whoa, watcha. I'm taking that phrase. The rest of the jury has heard it. The rest of the jury has been educated about it. Not from a lawyer, but from one of their own. Let me give you an example of racial bias issues. I mean, I'm a short white dude from the South, okay? And my dad was a little bit of an older dad, so he was, I'm in my 40s. He was, well over 40 years older than me. And so he was of a kind of a whole other generation beyond a lot of my friends' parents. And he grew up in the 1930s and the 1940s. My grandmother was in her 80s when I was a little kid. And so just a whole different generation. And I can remember in first grade, my best friend in first grade was Matthew. Matthew and I did everything together. We'd talk on the phone together. We got calculator wristwatches together. How many of you remember calculator watches? Yeah, those were cool, right? That's an early 80s thing. We had those. When the A-Team would come on TV, we'd pick up the phone and we'd talk to each other on the phone while we watched the A-Team. Yeah, that's cool. Did you see what Mr. T did? We were really close buds. We were close friends. And that was first grade. After first grade, we moved to another town. And I had to start over and make new friends in second grade. And I remember my grandmother and my dad, both of whom are dead now. And I love my dad dearly. But they sat me down and they said, the next time you pick your best friend, make sure he's not black. That's a filter I grew up with. Do any of you have any similar experiences like that? Now I'm asking jurors this. I've shared something intensely personal to me about people I love who had hatred in their heart and tried to put it in mine when the innocence of a child, there was none. All I saw was my friend Matthew. He liked the A-Team. I didn't know the color of his skin. I didn't care. But then that's a filter that I had to grow up with, and then through education, remove. And so what you're trying to get at is what filters do your jurors have, and get them to talk about them. All right? What I just gave you is an example of what I do in a case when I know I'm going to be dealing with racial issues. Same thing with mental health issues, gun violence, drug and alcohol abuse. Let me give you an example, and you've got this in your materials as well. I had a case where I was representing a young man who, classic example, in federal court, he was charged with being a felon in possession of a firearm and possession of crack cocaine in furtherance of a drug trafficking crime. He'd been in and out of prison the past 20 years, had tattoos all over his arms, all over his face, including little teardrop tattoos and gang tattoos, some gold teeth. And he had a bullet lodged in the frontal lobe of his brain. He had scars and wounds from other gunshots he'd endured just by growing up the way he did and living in the environment that he had lived in. Now, in federal court, and a lot of you know this, your jury pool is not limited to your urban area, right? It's the whole judicial district. And so, I'm in an urban area in Knoxville, Tennessee, but I'm in the center of Appalachia. And so my judicial district covers a real broad swath. I've got the Oak Ridge National Laboratory, which is one of the Manhattan Project labs in the country. We still we disassemble nuclear weapons there, like from Kazakhstan. That's a little scary, but one of these days I'm just going to blow up and we won't exist anymore. But you've got people that have 5 PhDs there. It's the highest concentration of PhDs in the world are at that national lab. So you have people there, and then you've got per capita, highest concentration per capita. But then you'll have some, good old boy or good old girl from a holler out on top of a mountain. All right? Or someone who's affiliated with some white supremacist group somewhere. It's a really broad swath of of people you get on your jury. And a lot of times you'll end up with more of those people on your panel than the people who are in the city. And so I ended up with that kind of panel for my client who had the bullet in his head. Okay, he was a young black man. Not one black juror even in my panel. And my defense in that case was going to be, he may have been a felon in possession of a firearm. We'll stipulate to that. He didn't possess that crack to sell it. He possessed the crack to use it, to smoke it. He has recurrent pain, and it helps to treat his pain. He doesn't have the gun in furtherance of drug distribution, but for self-protection, because he's lived in a war zone his entire life. So I start that jury selection by talking about, how many of you ever served in the military? How many of you have friends or family who've served in the military? How many of you have gotten, have had a friend or a family member come back from a war zone and kind of been shell-shocked, what we call now PTSD? And I got people to talking about that stuff, all right? And so got them to identify through the people they knew or them themselves with my client. They acquitted him too. See how powerful this is? You've got to get them to identify with your theme and your theory. I was also able to weed out the people that I knew would not agree. All right, let me talk about demonstrative aids. I love demonstrative aids. I love toys. I'm a computer nerd. Okay? I am. I've got Mac computers. I've got Windows computers. I've got presentation slides. A lot of times when I give talks, I have movies and all sorts of other stuff. And so we live in a world today where people are constantly inundated with more than just people talking to them, right? They're used to other things that are visual. How many of you use PowerPoint or some sort of visual aid in opening statement or closing argument? Fair number of you. How many of you in opening statement or closing argument maybe talk about exhibits that came in or hold exhibits up and show them to the jury? Yeah, even more of you. How many of you in the course of a cross-examination or a direct examination, you use a flip chart? You make an exhibit right there on the spot with the juror, or not the juror, but with the witness using a flip chart. Okay, fair number of you. And that's something that's interactive. It's something other than just someone listening to you talk. Jury selection is no different. I'll use demonstrative aids in the case. If I know a particular piece of evidence, let's say the prosecutor and I have stipulated that certain photographs are coming into evidence, there's nothing wrong with discussing the evidence with the prospective jury. In Massachusetts, that's built in your specific rule, even. And so I'll have a picture up. I tried a case the other day, more than the other day, a couple months ago, where a big issue was, transference of DNA material. The detective who had taken my client's underwear from the laundry basket put gloves on, but then threw the underwear down on a carpeted floor to take photographs of it. And so I've got these photographs of the underwear on the floor, all right, and I'm talking about DNA transference and epithelial skin cell transference and how much skin's in your, and what I was talking about is the little bit of DNA of the alleged victim who lived in the household that was on the underwear could be every bit as attributable to the underwear being on the floor that the detective put there. So I had a picture of the underwear on the floor in jury selection. I knew that's going to be a big deal, a huge deal, in the course of talking to the jury about DNA. And you can start laying these themes down. I start that out when I'm talking about TV shows, CSI, or any other TV show that deals with DNA. I'll use presentation slides. I'll have PowerPoint when I'm doing jury selection as I go from topic to topic. So why you outline this, okay? And you know what topics you're going through. It's organic, it's a conversation, but it's a led conversation. And so as I go from topic to topic, you've got my outlines in your materials. As you'll see, I've got that outlined, and I have in there what slides I go to when. so they can see that. Law of the case, the jury instructions. I'll start talking to them about the jury instructions. Okay, in Tennessee, we have a modified version of the Model Penal Code's accessory liability provisions called criminal responsibility for the conduct of another, kind of like aiding and abetting. And it's kind of a confusing statute. And I had one case where that was the whole issue, was whether or not my client, who was in the house when this horrible, horrific murder, rape, torture situation occurred, and his DNA is not anywhere, he had not done anything, he sat in the house and smoked dope while all this is going on. Issue was, is he criminally responsible for the conduct of another? Was he there sort of to have their back while they were doing whatever they were doing? Or was he scared, didn't know what to do, sat there and just smoked dope? Okay, criminal responsibility case. I knew that was a big part of the case. The whole case was going to turn on that. We started talking about it in jury selection. In the course of the part of, can you follow the law? What do you think about this? If this is the law of the case and you're instructed about this, could you do this? Could you hold somebody accountable? You know, we had a lot of people on the juries going, if he was just there and he didn't do anything, no. And we had some people on the jury saying, yeah, but if why didn't he go get help? You know, and it started that discussion early, and you can do that. The rules allow you to do that. Your theme and theory, we've already talked about. You start talking about that. You have transition slides. I'm going to give you an example quickly, and this PowerPoint is in your materials. This is just an example. I mean, I'll start out, state versus whatever my client's name is, Wadir. This is the Monk case. These were my Wadir slides during the Monk case. Okay? And, you know, I'll just start out. You know, the law is that in order for you to do something, you to be guilty, you not only have to do something, but you have to intend it. You have to mean to do it. All right? And that's an easy topic to talk about with jurors, right? Because, you know, how many of you not meant to do something? It was an accident. You know, we all hear kids say that. I didn't mean to do that. It's inherent in human nature. And so all you're doing is just educating them about that. And you ask them for examples about it once you explain it. And I'm drawing these terms of art from the jury instructions. There's going to be no dispute about what they're going to be instructed on. I'll go through reasonable doubt, what reasonable doubt means. You know, and you, part of your for-cause ability to get information from jurors to determine whether or not you should make a motion that they should be disqualified for cause because they can't follow the law, is you have to examine them on reasonable doubt and the presumption of innocence. And, you know, now think about this in a child rape case, child molester. How many of you, if you thought he was proven not guilty, how many of you would vote to acquit? You know, and you get people to raise their hands. All right? Now, what if you thought, I think it's highly likely or highly unlikely he's guilty? You know, and you get people to raise their hands. You just go through the degrees. Okay? Now, I love when I get to this. I don't really know if he's guilty or not. How many of you would vote to convict someone that could be a child molester, who had raped a child? Then you start getting your hands up, right? Because it's one thing to talk about the burden of proof in the abstract. It's another thing to talk about it for real. And this is when your for-cause stuff, you know, really starts going. Perhaps he is guilty. I suspect he may be guilty. I think he is possibly guilty. And every time they raise their hands, you don't just stop there. You go, why do you believe that? You get them to talk. Guilt is likely. Guilt is, how many of you think if guilt was highly likely, you would vote to convict? I use that chart in jury selection, but then I integrate it into opening and I integrate it into closing argument. And there's a lot of jurors that I get kicked for cause challenges. A lot of my bad jurors just on that chart. You integrate it into whatever the theme and theory is of your particular case, right? You know, what's your for-cause issue or issues in your case? A factual issue about your case that may cause a prospective juror to not be able to apply the burden of proof. So it's more than just saying, you understand beyond a reasonable doubt. Can you give my client a fair trial? Can you apply the burden correctly? That's crap. That doesn't get you anywhere. It's an example of that. In jury deselection, like I said, it's not really jury selection, it's jury deselection. You're beginning the process of empowering the individual jurors to each be your client's advocate during deliberations. Even if it's just that one juror, you're giving that juror the arguments that that juror needs to do what she needs to do to advocate your position. And people argue better if they're arguing their own thoughts or their own ideas, right? That's why you've only got one shot to talk to the jurors and get their own thoughts and their own ideas about the case. And so that's why I talk about using them as a focus group. That's when you get their own thoughts and their own ideas about the case, when you ask those open-ended questions. Remember the example I said where I had the prospective juror in talking about mental health issues saying bipolar's a bitch. Sometimes things happen and you just can't control yourself at all. They advocate their own experiences and their own positions. And so that when you learn them and integrate them into your theme and theory, that's the most powerful stuff that you end up having. Now, let's talk about questions. Any of you have questions? Left some time here at the end, about 10 minutes here at the end, so we could take questions. And if any of you have, particularly those of you that practice in Massachusetts and have not really had the power to do this before and are just beginning to do it, so we could talk about that a little bit. Any questions? I know it's Friday, and I know it's 4:50. Come on. Yes, ma'am. That jury selection took a day and a half. I had another case where, not dissimilar to that one, but where I was representing a sheriff's office lieutenant. He was a lieutenant in charge of warrants for the sheriff's office, who was accused of also molesting his stepdaughter. And jury selection in that case took 2 days. That's right. I mean, what you're doing actually that's a great question. While you're questioning the jurors, if you had, go back to my beyond a reasonable doubt chart, if you're right there at that point, you're questioning the jurors about those issues that you can make a for-cause objection to. And so at the moment you've got a witness or a juror that you think is for cause, what you do is you make your for cause objection. What we do is we make those objections at the bench. But you make your for cause objection, the prosecutor always tries to rehabilitate, right? And a lot of times I'm dealing with not only a prosecutor rehabilitating the juror, but also the judge trying to rehabilitate the juror. So I'm kind of fighting them both at the same time. And, if I end up, a lot of times there's back and forth with that particular juror about, well, now even though you said you would convict if it was just highly likely, you understand you have to apply the law and what beyond a reasonable doubt is. If I instruct you about beyond a reasonable doubt, you would follow the court's instructions, right? And yes, I would. And then I'll get back up and I'll try to de-rehabilitate that same witness. And so if I can get a bunch of same juror, if I get a bunch of equivocal answers from the juror, then, court's got to, as a matter of law, kick that juror off. Now, with peremptories, though, as I'm going through some of this other stuff, what the procedure that I can talk about my own personal experience anecdotally in various federal courts and in state court is once you conduct the total of your voir dire with that entire panel, the people that are being questioned right then you exercise your peremptory challenges. They come out of the jury box, and then new members come in to the jury box. And then the court will allow you to conduct individual voir dire, so go over some of the same stuff with just the new people. Okay? And so it's about engaging them in that same dialogue. And they've been out in the audience, though, while you've been questioning the other folks. So they've heard everything before. And so what you have to do is kind of go back through everything again that you already went through but do it in a little bit more of a truncated way with the new folks and get them to engage in a dialogue and answer the questions. And a lot of times, if I've got new folks that have come into the jury box, let's say I've got 3 new people that have come into the jury box, and so I'll say, now when we were talking a little bit before about teenagers and social media and texting. You remember that conversation, Mr. Smith? Yes, I do. And, do you have any kids? Well, yeah. Or the teenagers? Yeah. Do they have a cell phone? Yeah. Do they text? Yeah. And then start getting into a conversation with them. Did you hear what, then I direct to a juror who has been in the box a while and maybe answered a question before. Did you hear what, Mr. Johnson said? And yeah, and do you agree with that? What do you think about that? What's your perspective? Things like that. That's how that works. And then once you've gone through your whole process with the new jurors who've gotten into the box, and the prosecutor has an opportunity to do the same, then you exercise your peremptories. And then so that process keeps going until you're out of peremptories or you've got a panel that you don't want to exercise any peremptories on. And so I'll tell you what, I've had cases though that before I ever get to the stage where I'm exercising peremptory challenges, I've spent most of the day just on for-cause issues, particularly those really tough cases that may involve mental health issues or may, about just whether or not, the mental health issue in the Monk case was even if someone confessed they did it, and they did it. I mean, the facts of that case were just awful. He confessed that he had this 6-year-old jack him off and then lick the semen off of his penis and said it'll taste like a milkshake. Okay? That's a bad fact. All right? That's bad. But I started asking questions about it in jury selection because I don't want all of a sudden them hear that crap, here we are when the witness is testifying. I want to get out there. This is a bad case. He did it. What he did is awful. He has a mental health issue. Because he has a mental health issue and it requires both the actus reus and the mens rea, the dirty act and the dirty mind, just the old legal Latin, and he doesn't have the mens rea, so he's not guilty. I wasn't traveling under insanity. God knows insanity is just an awful, awful, awful standard to try to meet now after the Insanity Defense Reform Act. I was traveling under diminished mental capacity. He just wholly didn't have the mental state at the time. And so, on issues like cases like that, on my little beyond a reasonable doubt chart, I'm going through the for-cause issues of whether or not they can fairly even apply the law in a situation like that. Okay? That voir dire, just on those for-cause issues about being able to fairly apply the law, took a day. Took a day. Now, if you're in a jurisdiction, though, where judges aren't used to that, they're used to wham, bam, we got a jury in 30 minutes, let's go. Okay, that's hard. That's hard. But you got to push. You have to push. Judge, I can't effectively conduct my examination. Judge, I can't effectively exercise peremptory challenges. Judge, I can't effectively make a determination about whether or not this juror can fairly apply the law. And you just got to do it, and you got to make a record. You got to make a record. Yeah, Rod. Not other than just getting to talk, and just, there's a lot of, I use that example of abnormal psychology. 90% of human communication is nonverbal, right? That's what the shrinks tell us. And so that's why it's so important to listen and to watch. And so, Rock, it's just a matter of trying to, if I can get them to talk and get as much information as I can from them, then if I think someone wants on the jury because they want to sit in judgment of my client in that particular case, I want to put this child rapist in prison. I want to put this guy that defrauded this person out of their home loan in prison. I want to put this person who committed murder in prison. Okay? I'm trying to use all those other tools that I've already got up there. Yes, sir. Absolutely. But you can't factor that dynamic in unless you've gotten them to talk, right? And gotten them to talk to each other and to react to each other's responses, as opposed to just reacting to your questions. And so that's why you've got to listen, and if someone says something over here that is a sort of a trigger for you as to one of your themes or one of your issues, then boom, you've got to start asking other people questions. And that's why on the forefront, if you've got them scored and you know which ones are the ones that you think may be your bad ones, but you're not sure just based on the little bit of biographical information you have from the questionnaires, those are the ones that you loop back to and you try to get to talk. And even if they are really bad, I mean, look, there's nothing wrong with someone giving you an answer like, I don't give a shit what was going on in his brain. If he told a kid to drink it like a milkshake, he's going to prison. Or I had one guy, this was in a death penalty case once, where, examining a prospective juror, and he goes, gets Old Testament on me and goes, you spill the blood of man, your blood shall be spilled by man. Okay? Really? I mean, and he says that in front of the whole panel. Ugh. And so that's nothing to be afraid of. It's not anything to be afraid of, because then, well, why do you feel that way? Let's talk about that a little bit. Okay? And so if the law was this or the law was that, you couldn't do it. Not morally right. God's law. And so you use that person to bounce your theme and theory off of, and you're educating the other members of the jury about your theme and theory. So don't be afraid of bad answers. You love bad answers. You love bad answers. But yeah, in the course of getting them to talk to each other and bouncing, what do you think about what this person just said? Or, what's your experience with that? Getting them to interact in a group way with one another, you can see some of that dynamic. Yeah. Yes, sir. Yeah, nonverbal communication. That's why you've got to be quick. Try to figure out who gave you those 7 or 8 nods. Now, remember something else. Whose job is it to make the record of the case? The lawyer! All right? And so those 7 or 8 nods about fry the son of a bitch, I don't care what the law is. Okay? Those 7 or 8 heads that you see going like that, court reporter's not getting that down. It's your job to get that down. So you have to be really quick and say, Mr. Kuchecki, I noticed you were nodding in agreement when that comment was made by Mr. Smith. Do you agree with that? Tell me why. What do you feel about that? Okay? Or some jurisdictions you can only call them on the record by their number. Juror number 24, jury number 2. I hate that. That's junk. But that's what you do. Yes, sir. Yeah, it's really easy. All right. Lawyers are easy marks for technology, aren't we? Here's some piece of software that's going to help you do something really great. And we're like, okay. You can go buy it. There's like stuff now you can put on your iPad, do little things. No, don't fall for any of that junk. All right. How many of you in your courthouse, there is some sort of jury selection chart already present in the courtroom of kind of where the chairs are laid out in the jury box, and then wherever the court puts alternates, and then wherever the court puts the chairs for the additional jurors? Yeah? I mean, you got something like that? Here's what I do. Usually that piece of paper is either letter size or it's legal size, right? Okay? I just get that. How many of you have seen little bitty yellow sticky notes? The little ones, not the bigger ones, but the little ones. Come on now. Everybody should raise their hand there. What universe are you living in? So all I do is real quickly, I know who the jurors are in advance. I've got even if it's just the basic juror information sheet with just names and basic stuff that, it's part of the jury panel. As the judge is putting them in the box or calling them up and putting them in the box, or the clerk's calling them up and putting them in the box and identifying them, I'm writing down real quick the names of the jurors. If I've got someone sitting at trial with me, they just do the duplicate of what I do. They have the same little chart. They've already got little sticky notes on all the seats, and they write the names. And then if I've got them scored 1 to 10, beside their name, I'll put what their initial little score is, because I've got that separately in I've got my jury information organized. And so when I get up to conduct the voir dire, I take the little sheet up with me. That way I know who's sitting in which particular chair. It's got all the little stickies on it, and I'm able to call them by name. And then I've just got my legal pad up there with me as well, and I'm jotting down notes while I'm talking to them, and then I've got my outline up there. Okay? Now, do you see how hard this is if it's only you doing it, and you don't have somebody else to help you kind of watch and make notes and look at them and look for nonverbal cues and communication? And it doesn't have to be a lawyer. You know, like I said, I've had college students, law students, interns, staff members. I've had family members before just kind of sit there and help me with this process. You don't have to be a lawyer to do this stuff and just to help you collate information. But through the years, I've done all sorts of stuff. I've used computer programs. I used to take that same chart that I'm talking about, and I would go to like an office supply store and get it matted to a piece of hard cardboard, and it looked all pretty, and then I would take the juror information and make little note cards with it, then put a little sticky back on them, and that way I could just quickly, put that information on. And then finally it dawned on me one day, why the hell am I doing all that? Sticky notes and the chart. It works great. Now, some people, I don't have this capability with my memory. Some people do. But there's one lawyer I'm thinking of right now that I know. It's actually a prosecutor. That's what makes her so deadly, though, in jury selection. But as the judge is putting people in the box, she just has this memory where she uses this little device in her head, and she immediately memorizes all their names. And so then she can get up without any notes and go, Miss Cornett, blah, 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 and, Miss Sobieski, blah, blah, blah. And it's freaking amazing, and it's really impressive. All right? I can't do that. And most of the human population can't either. So the sticky notes and the chart is how I do it. And then, when it comes time to start exercising those peremptory challenges or those forward cause challenges, I huddle up with, particularly the peremptories, I huddle up with whoever is helping me, and we just compare notes real quick. And about what we heard, what we saw, what our impressions are. I keep my little notepad there because if a juror says something, a little nugget that I want to incorporate into my theme or theory, mental health issues are a bitch. You don't know what you're doing when something like that is affecting you. I'm writing that down. Okay? That's a great question. Yes, sir?
We don't have much experience in Massachusetts with this, so please accept this question. How do prosecutors do this?
They suck!
They must.
Yeah.
Will you fry them?
No, a big part of what prosecutors end up doing, if you're doing a good job with your jury selection, okay? If you're doing a good job, and what you're trying to do is front load as much of this as you can under the guise of for cause challenges, right? Because you're trying to get, can you apply the law under the certain facts of this case involving these sorts of situations? You may not be the right juror for this case. You may be the right juror over here in civil court to handle a car wreck, but you're going through that stuff with the jurors. And so as you're doing that and you're, really showing that a particular juror may not be able to do it, a prosecutor spends a lot of their time rehabilitating the juror. And so a lot of their time ends up being spent on the judge will instruct you that, you have to apply the burden of beyond a reasonable doubt to the state. It's a burden I accept. Can you hold the state to its burden and fairly apply the law? Yes. Okay? They spend a lot of their time doing that stuff. The really, really good prosecutors do all this same stuff that I'm doing. All right? They're laying out their theme and their theory of the prosecution. They're talking about the evidence in the case. And they're trying to do this exact same thing that we're trying to do, which is go ahead and advocate their case during the selection process. They'll do the exact same thing with the law. I mean, that case I was talking about with my client who was just present in the house when all this really bad stuff occurred, okay, and was smoking dope. It turned on this legal issue of criminal responsibility for the conduct of another under that statute. And so the prosecutor was doing all the exact same stuff I was doing and talking about things in terms of that statute and explaining it, asking jurors questions about it. Okay? Good question. Yes, sir? Are you talking about someone who seems like they're racially prejudiced and you're trying to get them excluded for cause, right? Peremptory challenge? Right. Everyone, the prosecutor's preempted is white and or is black, but I mean, that's just that's the Batson issue, and they've got, as you know, the prosecutor has to get up and let the judge know on the record a valid non-race-based reason why they exercised a peremptory challenge for that particular juror. I mean, if I've got a juror that I think is racially biased, then yeah, I'll try to make the for cause challenges as much as I can and try to tease that out, that just because of my client is so different than you, it's hard for you to identify with my client, that you can't fairly apply the law in this particular case. It's really hard to get people to talk about their racial prejudices. That's why I try to do it with stories, and I use my own personal story. And then, a lot of times though, and this comes from, it's actually an article that the great jury consultant Kat Bennett once wrote. How many of you are familiar with Kat Bennett, heard of Kat Bennett? She wrote once that, was talking about a particular jury selection where on race, where a personal story was told like I would tell when I'm dealing with that issue, and you're getting the jurors to tell their personal stories. And this little old lady was on the jury, and she, little white lady, and probably sweet as could be, but, she said, I don't think I have any racial prejudices. I mean, in fact, when I was a little girl, if colored people wanted to come by and didn't have any place to stay, because as we all know, there weren't a lot of hotels, before the civil rights movement that would, in certain areas of the country, that would accept people of color. She said that we would allow them to stay in our barn. We'd give them a place to stay. Okay, whoa, that's a great, you get to really do some stuff with that juror, right? Okay, she doesn't think she's racist. But then, by teasing that out of her and then talking to her, why didn't your parents let those guests stay in the house? If they'd been white, would they have stayed in the house? And then as soon as it dawns on her, oh my gosh, of that particular generation, she thought she wasn't racist. She thought she was progressive. But now she really realizes, I grew up with that. And maybe I still harbor some of that. Maybe my initial reaction when I look at someone of a different color is to look at them differently and deal with them differently. Then the issue really becomes, as Kat Bennett would say, do you leave them on? Because now she knows the filter. She's aware of the filter that initially she sees things with. And does that make her then stop and pull that filter back? And then also, does it make her want to educate the other jurors when they're in the jury room? Yes, sir. I think we're out of time. We're out of time. Thank you so much.